focuses on whether GCSB assets should be used to conduct surveillance on New Zealand residents. One can imagine a pre-Snowden world in which the GCSB reviewed the idea that we've been using as assets and that's worked well for us, and one could then slip to the idea that we just need to legislate to provide that. But at least the sense that's what you're getting from the Cabinet paper when you read it, that there was a relatively sort of unthought thinking from that proposition to what there's a solution. In doing so, it escapes over any serious consideration of the alternative. That's one of enhancing the existing domestic intelligence capabilities. Existing agencies could have that, and so preserving a clear separation between domestic surveillance and foreign surveillance for the reasons already well canvassed before this committee. The justification offered in the Cabinet paper for simply carrying on using GCSB assets rests entirely on the alternative being unaffordable, and it states in a single sentence, quote, GCSB Act Review considered that in a small jurisdiction such as New Zealand, we cannot afford to duplicate expensive and sophisticated assets, and there are limited numbers of people that can work on such assets. No evidence is provided in Cabinet paper to support the claim of affordability, so there is no disclosure of the estimated cost or even evidence that such an estimate has been formally derived. It is wholly inadequate to simply assert that unaffordability and to provide no indication of the costs so that such spending can be weighed and the balance can be assessed. Further, the GCSB Act Review that is referred to in the Cabinet paper is unadvised by GCSB, not actually a document but a process. So presumably there are documents that address this question, but there are internal ones. But the basic information on the cost of the alternative approach cannot credibly be deemed confidential. So it seems to me the key function of this committee process is to ask questions of officials in a way that will extract information needed to properly assess the claim on affordability. But when it comes down to it, the most controversial aspect of this bill is entirely predicated on the cost claim, so that needs to be tested. Potentially there is a way through here for all parties, if in fact there is an affordable alternative. So I ask the following questions, and I urge members of the committee to take up these questions. Number one, did the GCSB Act Review, that process, did it formally estimate the cost of duplicating the required assets when it declared this unaffordability? If so, what assumptions underlay that calculation, and what was the estimated cost? Did the review process formally estimate the benefits of duplicating the required assets? If so, what was that benefit estimate and what was the methodology used? I ask these questions because if there isn't a detailed cost and benefit calculation there, then the proposed reforms of Clause 8 really lack a really foundation. But ideally, what I'd like to encourage you even more is to think of this question in a different frame. Because we ask slightly different questions, you can get different answers. If you ask, what would be the cost of enhancing the surveillance capability of domestic security agencies such that their reasonable needs could be met in the most efficient way? That's potentially quite a different question. If you ask another version again, what would be the least cost of enhancing the surveillance capability of domestic security agencies such that their reasonable needs would be met, but they could use workarounds? Workarounds meaning you could impose, you'd have extra time penalties, other constraints on operations, but it would still allow the targeted information to be accessed. And after that, what you ask, point 5, is what would be the overall enhancement to the surveillance capability of domestic security agencies that would deliver the best trade-off in terms of dollars spent for information obtained? Cost-benefit analysis depends critically on assumptions used. If the estimate is framed around the cost of literally duplicating what the GCSB uses mainly for quite different purposes, then it would be fairly easy to get a big number. But if you ask questions such as the above that seek to draw out the trade-off points, how much extra money for how much extra delivery, you may well find that the additional cost is what New Zealanders are happy to pay in order to keep a clear separation between domestic and foreign surveillance. At that point, Clause 8 of the bill could be largely a one-line appropriation in the next budget instead of changing the fundamental understanding about how the GCSB will operate. I'm putting to you that it's a matter of reframing the question and asking, What would the police be asking now if there were no GCSB? What would they come up with if they employed the Rutherford maxim of we can't afford it, so we have to think? I'd note in this way that Trade Me succeeded where eBay shied away from New Zealand because it created software that could cope with New Zealand's slow internet speed. It made an adaptation to take up a number 8 wire principle. And I think we need to know what was possible here in the same way. We just haven't seen that analysis in public, and it's critical to do. However, if upon gathering up all the cost and benefit information it needs, the committee is still minded to allow GCSB assets to be used to assist domestic surveillance, then there are 2 other high-level issues I'd like to draw attention to. One is just, where is the restraint on the GCSB exporting data on New Zealand nationals? It would seem the most basic precondition for allowing GCSB assets to be used for the work otherwise undertaken by police or other department of state is that the information obtained by GCSB in the course of aiding domestic investigations would be statutorily barred from being shared internationally, yet no such provision exists in the bill. Now, note, I'm not proposing here to exclude the police or other agencies sharing that information internationally themselves, just that they need to do that in their own right. The bill actually establishes, more considerably, a clear permitted route for such international transfers. If you look at clause 25, the data that's been done intentionally as a result of the GCSB assistance to other agencies, that can still be stored under the simple justification of responding to, quote, potential threats to national security in New Zealand, unquote, which is a pretty low bar, pretty low threshold. Further, there's no requirement to report on the extent to which data was collected by GCSB on New Zealand nationals is stored or in any way exported. And the absence of those basic accountability provisions strikes me as a major factor. Finally, it's a great concern that surveillance of New Zealand citizens is not just at the request of other agencies, that the Minister can authorise us separately under Clause 8b. The scope of such approval is broad and there is effectively no limit on who the resulting information can be passed on to, so long as it's approved by the Minister. The bill also provides, as has been discussed, for the collection of metadata. Nowhere have I seen adequate justifications for these proposed powers, and it seems again that really has a role in drawing out from what is understood to be that review process that is not on the cabinet papers. What are the reasonable justifications that these exist? I really say again, if the committee nonetheless accepts that there is justification for those provisions, the absolute bottom line of the form is extensive public disclosure of the nature of the data required, where it is forwarded to, and what is stored, and this is done on a regular basis. There also needs to be provision for telecommunication companies to make parallel disclosures in their own right. This is the trend taking place in the US now towards that. So the bottom line here is the public wants metadata on GCSB and should be fully entitled to this under any reasonable set of protections to be applied if those provisions are to be taken forward. Thank you for your response.
I think you have a really important point, which I think you're right, it hasn't been properly explored before, which is the whole rationale for the bill is it's too expensive to duplicate the capacity. So it costs too much to duplicate it in the police or the SAS or whatever, so we've got to therefore the GCSB build a website for these other agencies. And yet, so far as we're aware, there's been no analysis of what the cost would be if what would be the least cost. I mean, I think that's the gaps that first point you're making. Is that right?
That's my central point in the contribution. I think it's really important to understand that when there's a review of something like this, if there are numbers to do like that, they may be bound up in documents which are confidential. I can accept that. But this committee can surely extract that information and get some idea of the assumptions that lay behind it. Because I've got through enough cost-benefit analyses in my time to know that those things are critically dependent on the assumptions. It's just possible that all parties could actually be satisfied by an additional cost spent by those other agencies to actually invest in a bit more equipment that may not be exactly, fees needs, not exactly what they want, but will do the job in Kiwi style and give us the critical protection